Matter of Kosmider versus Whitney. Please be seated.
Good afternoon. May it please the court. My name is Daniel Manning. I'm the county attorney for the County of Essex. I represent the appellant William B. Farabee, the chairman of the Essex County Board of Supervisors in this matter. As was stated in my papers, Mr. Farabee retired at the end of December 2016, and in his place, Randall Preston became the supervisor and FOIL's appeal officer, and so that I pretty much represent him also. I would like to reserve a minute for rebuttal, please. As you are aware, the issue in this case is whether electronic ballot images, which are copies of voted ballots, can be obtained by a citizen pursuant to a simple FOIL request under Public Officers Law, Section 84 et sec, or whether these documents can be obtained only pursuant to Election Law Section 3-222, parens 2, which requires a court order. As you know, Public Officers Law has various exceptions to this dissemination, and 87-2A, one of the exceptions is a statutory language that prevents the dissemination. Where I'm asking that this court reverse the decision of the Supreme Court, Essex County Supreme Court Honorable Martin Affredoux, and find that pursuant to Section 3-222, electronic ballot images are the same as voted ballots. They're nothing different than a copy. They contain the exact same data. They contain the exact same information. I'm asking that the court find that a court order is required for the protection of this ballot information. If I could indulge the court, a little history on the ballot machines. When an individual goes to vote, they're handed a ballot. They go to a shield or a blind. They vote. They bring the vote over to the machine, to the scanner. It's inserted into the scanner. It's scanned. There are two, in Essex County's case, there are two removable memory cards in the machine, which will take a picture of the ballot and they will record the vote. These removable memory cards are used over again, and therefore what happens in Essex County is the information from the removable memory card is taken from that card and it is placed on our EMS computer system, which is a separate segregated computer system that can only be accessed by a Democrat and a Republican of the Board of Elections. So those removable memory cards are used over and over and over again. So the facts, briefly in the case, are Ms. Kosmider requested through FOIL these electronic ballot images. And there was a disagreement between the two Board of Elections chairpersons. The Democrat wanted to allow it. The Republican said no. Therefore, it went to me. At that time, I was a FOIL officer. I ruled, after reviewing all this information, that 3-222 provided that a court order should be obtained. And thereafter, I was appealed to Mr. Farabee at the time. He found the same information.
If we were to agree with you that the election material were exempt from disclosure, yes, without a court order, what would that court order allow? Would it allow inspection or dissemination?
It would just allow, in my opinion, Your Honor, it would allow only inspection. The statute is very clear, 3-222, parens 2 and parens, says that it can only be examined. It does not allow for dissemination. So
now, you don't, but you need a court, if after 2 years the ballot may be disposed of, correct?
That's my understanding. It's my opinion that each of these four sections of 3-222 are very different and apply to very different situations. But for the sake of argument, I would allow after 2 years.
You wouldn't need a court order then. They could just go and ask you for it.
I would say no. And to be frank, 2 years is over, but it's still not a moot point, so I'd like to,
Why isn't it moot?
pardon me?
Why is it not moot?
It's been 2 years.
Well, because this is an issue that's going to come up again, and I think that's the standard for whether a court should address a matter that could possibly be moot.
Can I ask you about subdivision 2 for a second that we're
Yes,
talking about?
yes.
Okay. The purpose, in your view, just in your view, I'm going to ask the same question. Is the purpose to protect the integrity of the paper ballot from tampering, or is it to protect the information? Because the information is the same on the electronic ballot, the copy is the same, but the paper is different. So is subdivision 2 designed to prevent tampering or to getting the information on the ballot?
In the legislative history, there is mention that, and it didn't refer exactly to 3222 parens 2, but I think to some extent it is to prevent tampering. But again, they're only to be able to allow to look at the information. And the information in the electronic ballot is the same information on the voted ballot.
So you think it's to protect the information, or else you wouldn't need a court?
Yes, it is to protect the information.
That's the reason you need a court order.
The data is the same, whether it be the actual voted ballot or a picture, which is this electronic
And the
ballot.
tampering is taken care of because it can't be disseminated anyway.
Right, it's already been downloaded into our EMS system.
The information is the same in the electronic ballot as the paper ballot.
Exactly, and that's our point.
Could we get back to that mootness issue? Because you don't need a court order after 2 years. A citizen can come and ask for it after 2 years if you haven't disposed of it, correct? You only have to maintain the information for 2 years, correct?
Yes.
So I don't understand why it's not moot. Just the fact that it will reoccur again, that doesn't take it out of the mootness issue.
Well,
There's more to it than that.
it's my opinion that this issue is going to reoccur, and even though in our instance, it may, if a request is made, no such request has been made, a new request, but it's my opinion that because this could reoccur and happen again, that the court should address this and make a decision as to whether 3-222 parens 2M parens applies and requires court order.
Judge Afferdew said that that there hasn't been a demonstration that the state legislature intended to provide electronic ballot images with the same cloak of confidentiality as paper ballots. And he went on to say if the legislature intended to include electronic ballots images in the term voted ballots, it could have done so in the legislation. And how do you respond to that?
None of the sections of 3222 make any mention of electronic ballot images. My response to that is the legislature did provide that voted ballots cannot be disseminated or examined without a court order, and that an electronic ballot image is a copy of a voted ballot. It's the same thing. We get back to the data and the material thereon being disseminated.
When did you say none of the sections of 322 make reference to electronic data? I thought subdivision 1 specifically.
Oh, I'm speaking, I didn't mean to.
Yeah, I thought it's specifically referenced electronic media and the like.
In my opinion, it does not specifically make any mention of electronic ballot images, electronic copies of these ballot images. The only reading I make of section 1 has to do with the removable memory cards that are in the machine. And this section, I believe, was designed to prevent any tampering with those removable memory cards. That's it. And those removable memory cards cannot be accessed except for court order. And if there is no court order, then they're downloaded onto the EMS system, onto the computerized system. There's no other mention of what's to be done with them there. You take the next logical step to section 2, which has to do with voted ballots, and because an electronic ballot image is an exact duplicate copy of a voted ballot and has the exact same data, it could actually be if someone took a picture. I would argue they can't get that picture.
Once it's been downloaded and safeguarded, what is the need to thereafter secure it and keep it confidential?
I believe that has to, well, I don't know the legislature's intent with respect to that, but Section 2 specifically says they want to protect the voted ballot and only allow for its examination upon a court order. So if that's true of the voted ballot and the data is the same on the electronic ballot image, then it should be true of that electronic ballot image. Therefore, Section 1 relates only to removable memory cards and their sealing. That's it. That's all I read there. And no, it doesn't say anything about electronic ballot images. Section 2 likewise doesn't say anything about electronic ballot images. It's with regard to voted ballots. Our position is that electronic ballot image is a voted ballot because it's the exact copy thereof. Section 3 is quite a quagmire. It looks like in the beginning, I have to take it at its face value that it deals with packages protested void, wholly blank, open packages, absentee, military, special, federal, special presidential, emergency ballots, and boxes, ballot boxes. And I read that statute. It says nothing about electronic ballot images because you go back to Section 2. That's where voted ballots encompass that. This Section 3 deals with the boxes. The Section 3 does have provision for court order and for destruction after 2 years. And getting back to Judge Afferdew, and I think the same argument was made by Mr. Freeman, that, there's no cloak of confidentiality because they can be sold after 2 years. The point's missed, though, that before 2 years, there is that cloak of confidentiality under Section 2.
Would you like to keep your rebuttal time?
Sure. Yeah.
You could take a minute to conclude if you'd like.
Okay, I'll just conclude then.
No, you could keep your rebuttal time, and you can have a minute to conclude your argument as well.
Okay.
If you would like.
Oh, yes, I would like to. Also, as stated in my brief, election law, throughout the election law, there are opportunities for people to view ballots, to go to the 3% audit, to view the voting machines, to canvass, go to the canvass of the absentee, special, and regular ballots, and go to the recanvass of all the ballots. There's great mention was made of transparency and some of the other paperwork. Transparency, of course, everyone in this room and every true-blooded American wants transparency in the election process. It's one of our most coveted rights. That transparency starts with all these opportunities to view ballots or petition the court if you have a grievance on the ballot. And it ends with this statute is the last statute in that line that provides a mechanism to obtain copies of, or not obtain, examine copies of voted ballots. Therefore, there has to be some sort of an endpoint. The transparency, I'll argue we have transparency, all these opportunities to obtain this information, but this statute says once you reach this point, you've got to have a court order, and there must be finality in the election process. We can't allow things to continue, unless you go to the court and you make a good argument and the court says, yes, I will take these matters into consideration. One final point, I won't belabor this. We have 34 election districts within the towns in Essex County. Of those 34, on the conservative primary, there were 10 one votes on each 10 election districts. There was only one vote cast, and then another 6 of those there were 2 votes cast. If you can get this information without petitioning the court and giving a good reason this late in the game, and you can compare the poll book that you absolutely have an opportunity to review, you're going to be able to tell who cast that vote. And that flies in the face of the sanctity of the vote and the expectation of privacy which an individual has with respect to that vote, which is also an exemption under Public Officers Law, Section 87-2. Thank you very much for your time.
May it please the court. My name is James Walsh. I'm the attorney here for Commissioner Elsa McGahee. Commissioner McGahee is the Republican Commissioner of the Board of Elections. When I say the Republican Commissioner, that's because the Board of Elections is a bipartisan organization with checks and balances established within the election law to ensure that Republicans are watching what the Democrats do, the major parties, and the Democrats are watching what the Republicans do. So you have both parties checking over, making sure that they follow the law and that we follow what the election law has in it. Commissioner McGahee said that she does not want to have the documents revealed, the images revealed, pursuant to FOIL, and there's a very good reason for that, because she doesn't want to violate Section 17-126, misconduct of an elections officer, of the election law, which says, if you reveal to another person or communicate to another person your opinion, belief, or impression is how a voter is voted, that's a misdemeanor. So if the elections commissioner provides information that would reveal how I voted, that's a misdemeanor. Now, as you heard the county attorney say in Essex County, in the Conservative Party primary for 2015 for the judge race, which is what this is concerned, there were a total of 92 votes cast among these 42 election districts. 10 election districts had one ballot cast in them. These ballots have what town you're in and what election district you're in. You have the ability to go down and drill in and say which voter showed up and voted, cast his ballot, and there was only one vote. It's either for candidate A or candidate B. So the sanctity of that person's vote, his right to privacy, is gone. So when the elections commissioners provide the documentation and the data, they're revealing how those 10 people voted. And there's another 6 election districts that have 2 voters.
Are those facts that both Mr. Manning and you just made reference to part of the record?
Your Honor, we didn't have an opportunity to perfect the record because we were denied the opportunity for a hearing below. That we submitted an answer, I submitted an answer with an affidavit, and I fully expected a hearing to be set so that we could argue this in front of Judge Afferdew, but instead of doing that, Judge Afferdew made his decision based only upon our answer without giving us the opportunity to be heard with respect to the hearing. And I think that's because it's being classified as an Article 78 proceeding because of the FOIL and the ramifications of making the FOIL application, then going to the records access officer, and then taking the appeal up to the person who's above the records access officer. That's within normal FOIL procedures in Article 78, and that's perfectly normal there. But here what you're asking for is these protected documents that are really elections documents. You know, transparency is beautiful until you're looking over my shoulder to see which oval I'm filling in. I don't want people to see which oval I'm filling in. That's what this law is set up for. When you look at Article 17 of the election law, you see it's replete. You cannot sell your ballot. The reason we make it so you cannot sell your ballot is because we want to protect the integrity of our electoral process. If I mark my ballot with 3 pinholes, or I mark it with a special way that's identifiable, I can tell the Board of Elections, I'm the guy that marked it with the 3 pinholes next to it. That's a misdemeanor.
Is anybody here seeking a remittal in a hearing, or
Your Honor, I don't, at the very least, we ought to have a remittal and a hearing on that, but I don't think we go there. I think honestly, Your Honor, that the statute's very clear in 6-122-1, 6-122-2. This is not foilable documentation. This is information that the legislature has foreseen the need to, A, protect it with Article 17. You can't tell people how you voted. I can't take a picture of my ballot and send it out to the world. That's a misdemeanor, because I revealed how I voted and somebody could try to reward me for that. So we protect the sanctity of the ballot box. We don't want people looking into how I vote. I don't want to be able to be given credit to somebody later on. You voted the right way, so here's a job, here's a cash payment, here's a sandwich.
Although you were denied a hearing, this is a statutory interpretation, so we can make the decision you're saying.
Yes, Your Honor. I think the statutory interpretation is that when we look at this, you don't get to walk out with copies of ballots. You get to walk in with a court order and inspect the ballots that are contained within the machines. Now, the way that the scanner happens is the scanner does 2 things. In the card that you're given, it's a portable memory device. It's like a thumb drive almost. That portable memory device so when you go back to the Board of Elections and plug it into their main system, you had an automatic tabulation, so you have instantaneous results of elections. So you're giving the people their ability to preserve and look at their elections. Your Honor, I apologize. I did not ask for my 2 minutes rebuttal time, but I would like to retain that.
okay?
I had asked him about the mootness issue. Can you address that?
It's not moot, Your Honor, because if they reveal it, it's a violation of the election law. They're
No,
committing
but after
misdemeanor.
2 years, you don't need a court order.
But I would go back to what the election law says. There's no statute of limitations contained with Article 17 of the election law. They'd be committing a misdemeanor if they tell somebody else voted.
So
when you
after
have,
2 years, that could not be turned over, although you don't need a court order and you can dispose of the material at that point?
I think you can dispose of it, Your Honor, but if you communicate it to a third party that's going to reveal how someone votes,
So
you're
I
liable for
couldn't, I
misdemeanor.
couldn't as a citizen come to you and says, I want the information, because that would be a misdemeanor, you're saying?
I would say yes, you're subjecting these election officials because it's official misconduct. And that's again at 17-126.
Is that only because there was one vote in those particular elections?
Well,
Would that same principle apply if there was thousands of votes?
Your Honor, you're going to be asked to apply a rule that's going to apply across the state. And if you go down to a primary in Nassau or Suffolk County where hundreds of people vote in every election district and even in the minor parties, you know, you still with the Working Families Party might have 2 or 3 people that show up to vote. When you have that small of a subset casting a ballot, you can reveal how those people voted. So when you're asked to make these grand pronouncements about what should be turned over or what shouldn't be turned over, Essex County is the perfect one to use as a litmus test. You have 10 election districts where 1 vote was counted. That's 25% of their election districts where you're going to know how that person cast their ballot. Because the election district result, A or B candidate, with the sign-in book on who signed in to vote in that district, reveals how voter A voted, A or B. And so I would say it's not moot because you're going to ask the elections commissioner to commit a misdemeanor. And I think that we can't, if we're asking to produce this for a broad rule that's going to respect everybody, we you know, following the Socratic method, we've got to think about every possible person from this election district in Essex County where you've got 1 vote, and the Conservative Party isn't the Working Families Party. It isn't one of the other minor parties that barely qualify with the 50,000 votes. They're a pretty substantial party, and when only 1 person is voting in 25% of the election districts, that might not happen in Nassau County, it might not happen in New York County, but when you're dealing in some of the smaller counties upstate, you get into Hamilton County, you get out into the western part of the state, you get to a minor party, you're going to have 2, 3 people voting, and if they all vote the same way, then you know how they all voted.
This misdemeanor thing, so if before the 2 years is up, you get the court order and it's inspected, there's no misdemeanor because the court is ordering you to allow the inspection.
To allow the inspection, yes,
Right,
Your Honor.
but after 2 years, when the statute says that, you know, the ballot may be disposed of at the direction of the officer or the board having charge of it, if the citizen comes and asks, since you can dispose of it, they don't need a court order at that point, you're saying it's a misdemeanor at that point?
It's still a misdemeanor because that's how the person voted, Your Honor, and so I would advise my
So the
client.
only way around a misdemeanor is if it's with a court order, and it has to be within the 2 years?
It would be, and it would have to be even sooner than that, Your Honor, because Article 16 of the election law places a very small time frame. You have 20 days in which to bring an action under the Article 16 of the election law. So it has to happen even faster than that. I would advise my client, I've got an elections commissioner as a client here, I'd advise any other client, don't turn that over, destroy it. If you don't have to maintain it anymore, have it destroyed. Have it shredded, get rid of it, because you don't want that data, you don't want the liability, because the statute of limitations hasn't run yet for Article 17. And when you're revealing how somebody votes, I think for that misdemeanor, I think you've got a 5-year statute, if I'm not mistaken. So when you reveal how I vote, that you can have that liability.
So the citizen can't come to you after 2 years because it's a small window for them to petition for that information. Is that what you're saying?
Well, in those bigger counties, Your Honor, where you have a county with thousands of votes in that subset of the primary of the Conservative Party, and you've got 500 people voting in election districts, or even 100 people voting in an election district, I think that's fine information to turn over. But when you get to the smaller counties of Hamilton or Essex, or some of the other counties where they have 1 and 2 people in election districts voting, I think the better practice for the commissioner is to destroy it and not turn it over to anyone.
But then you're treating the citizens different based on where they're located. I should have the same right based on the statute as the next citizen in a larger county. If after 2 years I don't need a court order, I come to you and I ask for the material, you're going to treat me differently because I'm in a different county?
But Your Honor, you're treating me as the voter differently because you're revealing how I vote, and that protected the sanctity of the electoral process. I want to protect my right to privacy of how I vote. So why should a person be able to have that revealed? And that's really what you're protecting. You're not trying to punish or treat differently the people asking for the ballots. You're really protecting the voter the person who doesn't want you to go behind, they don't want the transparency to look down to see which oval I fill in, A or B.
Can you exactly, I might just be missing this a little bit, can you exactly explain how that occurred, how that would occur?
Well, Your Honor, if I go to vote in a primary, and I'm the only person in the town of Day, Election District 4, and I'm the only person voting, and I vote for candidate A, that image is going to have, the ballot has Town of Day, Election District 4 written down on it. So now they know how that person voted, and when they go and see the only person who signed in from the Town of Day, Election District 4 to vote in the primary was Jim Walsh, then my vote is revealed. So that's why I say it's not so much about trying to hurt the people asking to look, it's about really protecting the voter and the individual voter from how their canvass was, or how they exercise their right to franchise.
I guess I just don't understand where in the statute gives you that discretionary power to decide which citizen after 2 years get the information, which didn't, because you're saying that hinges on whether or not you're gonna violate the law.
Your Honor, I think that comes back to the Elections Commissioner. The Elections Commissioner has an obligation to ensure that they don't provide the ability for anybody else to find out how one voter voted. And when you're opening one absentee ballot in an election district, sometimes you can figure it out if you try to figure it out, but it's against the law to communicate it. You
Okay,
can't give it to
so
anybody
1
else.
versus 5, does it make a difference? Can you still figure it out? And when do you stop? When do you decide that, okay, after 5 people, we can't figure it out, so those citizens can get the information, if 2 years have passed?
I think that when you know as an elections commissioner that all 5 people of this election district voted the same way because all of the votes went to candidate B and none went to candidate A, you can't release that information because that's how the voter voted. But then I want to hit the last point in my brief, which is the public policy. We need elections to be over. Voters need to have confidence in the elections. How I started this was we have an electoral system set up that you have a Republican commissioner and a Democratic commissioner. That's the check and balance. That bipartisan approach is they check each other to ensure that nobody is doing something that's wrong in the election process. Even in counties that I don't think Essex County, at one point they had no Republicans on the Board of Supervisors, but they still had a Democratic elections commissioner that their job is to be the watchdog on the party in power. And you can't have one party taking a step against the other party. We like that because the provision makes for us to fight it out, to see where we need to be. And if there's a problem, we go into court, and the court will make a determination and have the canvass reviewed. The voters have a right and an obligation to have confidence in those results. And if we drag out and allow 2 years later to have foils come back and they say, hey, this guy really wasn't elected to the county legislature, they're in a 7-6 split, every action of that county legislature could be called into question for 2 years. So if you need to have confidence in your government, you need to have confidence in how you proceed to be able to 2 years later open it up and say, boy, he only won by 1 vote, but really it was a miscount, and so now the other guy would have won, and that would have switched the power base in the county. So everything they've done for the last 2 years, we're going to bring in Article 78 and object to it because you got the wrong person there. So that's the can of worms I'm afraid that you open up, and I really want the court to consider that public policy concern about ensuring the public's confidence in elections and the public's confidence in the determination of who's in power. And the reason why we have a 10-day, 14-day, 3-day statute of limitations of the election law is we want a speedy determination. We don't want to be litigating it for 2 years, Your Honor.
Thank you.
Thank you.
Good afternoon, Your Honors. My name is Daniel Novak. I'm here on behalf of Bethany Kosmider, the petitioner in this action. This case is about 2 important interests: the people's right to know the business of their government and the safeguarding of the integrity of the election process. Now, my adversary would have you believe that those 2 interests are in conflict. They are not. There's no reason why a petitioner's interest in seeking ballot data would in any way invalidate an election. There are many reasons to look at an election. Academic reasons such as studying vote splitting behaviors, even an interest in whether or not the machines are working as intended. But before Before I got to get into the sort of substance of my brief, I want to address my adversary's arguments about this misdemeanor law. This is not in the briefs, so we're really off script here. I have had no opportunity to ever assess this argument. I'm wholly unfamiliar with that statute. I don't think it makes any sense, frankly, but to the extent that I am understanding his arguments, I think it can be laid to rest fairly simply. If there's only one person in a district and that vote total is reported, anyone can go to the election roll and find it. The ballot image wouldn't tell you information because the ballot image doesn't have anything that the public total wouldn't have on it anyway. So if I'm making sense here, there's no new information to be gleaned by going to the image record here. And there's another point that I want to clarify here. The ballot images are not the same information as the voted ballots, the paper ballots. The ballot images are not only an image of the voted ballot, they also contain a stamp. It's called a cast vote record. That's a watermark that's added to it that tells you how the machine interpreted the paper ballot. So, for instance, someone interested in assessing whether these machines are working because maybe they malfunction or out of concerns that they could be susceptible to tampering, could look at it and see whether or not the scanner is actually behaving as intended, and compare the mark that's been made by the voter to the cast vote image, a watermark on the that's embedded in the vote record. So they're not the same. They shouldn't be treated the same. And Justice Pritzker raised a question about whether or not the purpose was tampering or information. My adversary conceded it's tampering. Tampering is the concern here. The reason why voted ballots, the paper ballots, are treated separately from the ballot images is because those are the backstop of the election. Those have to be treated inviolate and stored in a lockbox sealed against tampering. Now, we can't have people accessing them to look them over without judicial intervention because that would invite all sorts of misconduct potentially, or just error, negligence, and losing them. Once the ballot images, the memory card has been preserved, that concern has gone out the window. There's no concern that the actual paper ballots, which will always be the final backstop for determining the validity of the election, they're safe. So therefore,
because the image, the electronic image is first on a thumb drive, it's taken out and then stored on a permanent hard drive. Is that what you're saying?
Correct, Your Honor. And the statute is clear here. It says, removable memory cards or similar electronic media shall remain sealed against reuse until such time. Until. I mean, in my view, that's fairly dispositive. Once that step has taken place, it should take place ideally instantly after the election so that everything is where it should be. The data is secure. They have their copy, and there's no harm in providing access to my client or any interested party. Now, my adversaries have gone to great lengths to make this about some sort of effort to figure out who's voting for who or become about vote selling. It's a parade of horribles that just seems to me to be fanciful and remote. This is really just about FOIL. As citizens of the state of New York, our right to know the business of government. And when data is created, it's the property of the people. Now, there are exceptions to that are well recognized. But if they're not enumerated under the FOIL, then they have to be specifically exempted in the statute. Now, Judge Affordeau got it exactly right on the number when he stated that Respondent Farabee reads much more into Election Law 3222 than is presented in the statute's text, offering a, quote, artificial or forced construction of the statute. Even Mr. Farabee himself, in his initial rejection of my client's petition, conceded that the statute was vague. Now, he said he wanted to err on the side of caution. Those are his words. That's not how New York law works in the FOIL context. And FOIL is to be construed liberally. The tie, to borrow a baseball analogy, the tie should go to the runner, the petitioner here. That's if it's even a close question. This is not a close question because the very interests asserted by the statute, which is to protect the physical ballots, to protect them from tampering, to ensure the physical security of the election. This is not about the finality or any other sense. We have had, in recent events, many contested elections. One in Virginia, I believe, was decided by lots because it was too close. I think that we give, my adversaries give New Yorkers too little credit that we can't accept that sometimes the results don't go the way you want. This is not about relitigating an election.
So do you agree that the materials are exempt and you need a court order to get it?
So, excuse
Do
me?
you agree that the materials are exempt and you need a court order to get it?
For the paper ballots.
Right.
Correct.
And do you agree or disagree that was the judge correct to order dissemination instead of inspection?
Yes, Your Honor, because in this case, the statute is silent on anything relating to FOIL. So this statute's not a FOIL statute. As much as the County of Essex would like this to be in conversation with FOIL, it's not. The statute mandates confidentiality, strict confidentiality for paper ballots, but otherwise not. The legislature manifested no intent to keep secret the results of these ballot images. And in fact, numerous counties across the state have routinely provided them, including Essex County previously.
So once 2 years has passed, isn't the issue moot? You could just go and get access for the information?
No, Your Honor, the county, or any county really, is free to destroy or sell the ballot. So in this.
So waiting 2 years, it may be destroyed, so you
It
need
may
to
be,
go
yes,
before.
and in this case, we have there's no satisfaction. We don't know whether or not what the intentions of the county are. We're hoping that they have taken the steps necessary to preserve them during the pendency of this case, but otherwise, if not for Ms. Kosmider's petition, they could very well have been destroyed by now. So we really are dealing with an issue that's very alive.
Counsel, just assume for argument's sake, I know you're not conceding this, but assume for argument's sake that the purpose behind the subdivision 2 was not just to protect the paper ballots themselves, but was to protect the information contained therein. If that were the case, would you agree that the electronic ballots, except for the watermark you talked about, are essentially the same as the paper ballots?
If the legislature had manifested that intent, yes, I think we'd be having a very different conversation.
Okay, thank you.
Yes, but in FOIL, the first rule is the four corners of the statute here. The statute does not address it, frankly, and so then you can look to the intent to see if there's otherwise some sort of clear, desire to address it. Maybe it was vague, but you could see that they were trying. That's not in here. Even the title of the statute was. The preservation of ballots and records of voting machines. They're just preserving them. They're not saying secrecy of ballots and voting machines. So even in the record now, Judge Afferdo did consult the legislative history. We do have affidavits, so it's not as though that Judge Afferdo was unable to examine the intent of the legislature. Just the legislature did not intend to do this. Now, as I mentioned previously, numerous counties have released this in the past, including Essex County. We haven't seen the parade of horribles that's been suggested. And so the legislature presumably can be, I think we can infer awareness that, for instance, the city of New York has routinely released them, according to and that's in the record. Now, if the legislature thought that things weren't going as intended, they could fix it. And that Judge Afferdo did point to that in his decision, that if they were vague and were trying to, though he could not infer it from them, the legislature is the correct person to remedy this, not an individual who's worrying about a misdemeanor charge that I can only imagine, I don't understand the significance of, but that's not the person who should be deciding whether or not citizens have access to ballot information. One other thing I think is worth mentioning is that, there's many reasons besides wanting to just overturn an election. That might not even be the reason here. Now, I don't know my client's reason for wanting to look at them. I think it's totally irrelevant. This is a FOIL case. Citizens can look for information for a good reason or a bad reason or any reason in between. But we have seen good reasons to look at them. As I stated, academic ones, interest in making sure the machines are working as intended, and asking citizens, anyone who's interested in how an election is working and making sure it's working well, to canvass every single election, to be there physically, to be across a very large state. I, for instance, have driven a couple hours to be here today, and I'm very glad to be here, but I don't think that's a realistic ask for most ordinary New Yorkers to be sort of a roving electoral police here. So, and so the fact that there's a finality interest in the election's done. We're not overturning it, no matter what we find in the ballot data, should we receive it. So I think that America, we've seen enough instances where we've had some ugly races and tough calls. Bush versus Gore comes to mind, and people seem to be able to live with finality, even if, the results aren't what they hoped they had been. Unless you have other further questions, I have nothing more to offer. Thank you.
Good afternoon. My name's Jim Long. I represent now Sue Montgomery Corey, who is the new Democratic Election Commissioner in Essex County, Mark Whitney having resigned. This case is not about an election whatsoever. It's not about showing that somebody else won. The time for all of that expired 20 days after the election in November of 2015. It's about FOIL. And 3222 has three serious components. The first is preserve sacrosanct the originals, and therefore, should there ever be an issue or the Senate or the Assembly Committee wanted to do an investigation, the originals are safe. Second, download those memory disks into a master file, and then you can throw away the disks or cleanse them or and reuse them if you want. And then, to me, the great irony is, or wait 2 years and you can buy this. So forget about the misdemeanor. And as my learned colleague, Mr. Novak, pointed out, it's done all the time in recounts. We get to an election district, there's one voter. So we all look to the heavens and don't look at the name, and then look at the ballot. It's silly to think that I couldn't figure out who voted for who in an election district that only has one person who voted. I don't need to go look at the electronic image, or I don't need to ask for a court order to look at the ballot. It's obvious. It's sad, but it's true. Most election boards of elections I know, when they have a situation like that, they merge the 2 or 3 or 4 or 10 single vote districts. And so now we have 10 ballots commingled, and we cannot figure it out unless, of course, it's 10 to zip, which also does happen. So the issue here is about the right to access to records. It's not about changing votes or changing election results. It's certainly not about selling somebody's vote. That is not what this is about. It's about public access to records which are not protected under the FOIL. Thank you.
Just a couple quick points. The statute is clear. There is intent by the legislature that any voted ballots, and in my opinion, whatever form they may take, maybe a copy, a picture of it, electronic ballot image, you have to have a court order. And in my opinion, the court did this. This is a statute that is the last in a long line of different statutes that provide various mechanisms for access to ballots or to any agreed party. And the purpose of this statute is to put some finality to the election process. If you have a valid and legitimate claim, then go to the court. The court will decide it, and the court will then decide whether to allow the examination, and examination only of the ballots. And the court, in situations where there's only one voter in a district, a wise court would probably in camera not show what district that is, but show the ballot. You don't have to, I would imagine you'd have to show the district to show that there's any tampering or anything. So there is clear legislative intent which jibes with FOIL. FOIL, yes, is to be liberally construed, and except, however, when you can determine the intent of the legislature in a specific statute that specifically exempts something. It's my position that the word voted ballots means what it means. This is all about the definition of what's a voted ballot. A voted ballot is a ballot or a copy of a ballot that has the information and the data of the election or of the particular voter.
What about how do you reconcile that argument with the language that follows in subdivision 2 that speaks to packages thereof?
The packages, I don't know, Your Honor, to be honest with you. I don't know if that's
does it-
something left over from when they did have packages, because obviously you don't package electronic ballot images, they're sitting on the computer.
Well,
But I think they did revise 32221 and didn't do much to 2.
Well,
I don't
doesn't
know.
that seem to suggest that the voted ballots that's being referenced in the first 2 words of subdivision 2 is speaking to the paper ballots and the paper ballots only? Because they're the only things that are maintained
Well,
together in packages.
Again, I go back to, well, yes, but it says voted ballots, it doesn't say paper ballots. You know, if they wanted to say paper ballots, maybe they would have changed that to paper ballots.
Well, does packages thereof make any sense in connection with removable memory cards or electronic media?
First of all, I distinguish between removable memory cards and electronic ballot images, because those memory cards are just, that first paragraph in my mind, it just preserves those until the information is taken off and they can be reused again. I do agree they don't package electronic ballot images. They're sitting in that computer and safe and sound.
Do they package removable memory cards?
It's my understanding from speaking with my election commissioners that they reuse those removable memory cards. So that's the reason that we have 3221, is to protect that information so that when they're reused, that information has gone elsewhere into that computer. So that's all I read 3221 as having anything to do with it, is it's just removable memory cards and the protection of those until they're unsealed. And then, again, you skip down to voted ballots. To state that other counties have done things differently, that's the choice of the counties. There's been a split. It's in the papers. And I just want to clarify, I was given this same issue a year or 2 before, I don't remember. I'm a jack of all trades in a small county. I looked at Mr. Freeman's opinion, said, okay, yep, and I did give access to those. But then when I got into this and saw the statute, I felt otherwise in reading, carefully reading the statute. And I respect Mr. Freeman, but I disagree with his final conclusion. So I won't belabor this any longer, but I would ask that the decision be reversed, and then that the court find that a court order is required in order to allow the examination, not the dissemination, of these ballots only by court order. Thank you very much.
Thank you, Your Honor. I'll be brief as well. One of the things I wanted to clarify here, Your Honor, is the fact that when you mix 5 ballots, you're attempting to protect the 1 or 2 individuals that are in an election district, and it doesn't negate the fact that these images will reveal the district and the town on the image, the ballot. I also wanted to point out to the court that because of the legislature foresaw the possibility that there would be tight races and contests, that there's an audit that happens, and the audit that happens that there's an automatic audit of 3% of the machines in a given race, and if there's discrepancies found, i.e. the voted ballots don't match up with what the numbers that the machine says, the scanner says, then they do a 5% audit and they expand it. And if they still don't have further confirmation, Columbia County, for instance, does a hand canvass of everything. But by and large, they rely upon the totals that the machine, the scanner, tells them they have. So when you start looking at the images, that you're really looking at how the ballot was cast, and those images don't protect town of day election district 1. That's there. When you jumble, as my co-counsel and learned colleague said, when you add five in and you put the tally together of 5 election districts, then you're hoping you have 2 from one candidate and 3 for another. Nobody can tell how that goes down. But when you see those images, you know exactly what ballot is for what town and what ED. So that it is a protection of the right to privacy. It's a protection that's envisioned by the law. And if we look at subparagraph 2, it talks about all the data. It doesn't just talk about the write-in ballots. The packages are the packages of write-in ballots. So the write-in ballot is segregated because it has to be examined. They have to hand tally it because there's a name written in. There's not an oval that the scanner takes care of. When they hand tally it, they put that together and they put it in a package. That's all packages thereof. That's talking about those write-in ballots, Your Honor. So it's the data, it's the ballots in the machines, because they have to take them out for the next election, and it's those packages of the write-ins. That's all protected for 2 years at least, and set aside in case there's a quo warranto or there's an order, a timely order within 20 days that the court says, let's inspect them. You have access to them. You don't get the image and go home and review it. You don't take that data and do whatever you want with it. You get to go into the board and inspect them by court order, and only by court order. And again, it comes back in the integrity of the system and the protection of the electoral process. Thank you, Your Honor.
Thank you all. Please call the next case.
Next case is case number 523508, matter of Link versus Ehrenreich.